because the speakers have some difficulties to get out of Europe. So we postponed it. But this one is very interesting, is a qualifying quantity of smartphone-centric humans via human-centric method by Dr. Kazana, the speakers. She is a professor of Stanford University and University of Copenhagen. And please use Q&A in Zoom for questions, chat, or raise hand for technical issues. Please be very close to your PC when you speak for better audio recording. Announcement for jobs or other events posted on Meetup comments. And here is our speaker, Steve Bachmann, and he has been active in the Bay Area and started as the Bay Area working. So he is very knowledgeable in a lot of technical issues. He is specialized in patent and intellectual property matters and has practiced IP law in Silicon Valley for 20 years. Before being an IP attorney, he worked as a design engineer with the National Semiconductor in Santa Clara, California, on integrated circuit in audio technology group. Steve has represented clients in all aspects of patents and intellectual property portfolio development, including open source strategy, licensing and technology transfer negotiations and drafting. Steve has a broad range of substantial experience in protecting AI technologies, including machine learning, computer vision, neural networks, natural language processing, intelligent agents, with applications using AI in both software and hardware. Let's welcome Steve Bachmann.
Hi, Liana. Thank you very much for the intro and for all that information. And I'd like to thank all of you for joining today. I know it's a different time we're in now. And it looks like it might be the new normal for at least a little while, but we're happy you're here and we're excited to talk about the subject. So why don't we get right into it? So as Liana mentioned, my name is Steve Bachmann. I'm a patent attorney. I've been a patent attorney for about 20 years here in Silicon Valley. I've worked with big firms, I've worked with small patent boutique firms, and for the last 10 years, actually for the last 5 years, I've had my own law firm here in Silicon Valley. I've worked with clients in several different areas, and in particular have a lot of years experience in artificial intelligence. I'm looking forward to sharing some of the things I've learned over the last few years with you. So there are a few topics I'd like to discuss with you all today. Let's see, first we're going to kind of do an overview of artificial intelligence. Let's kind of talk about a basic definition and some of the types of artificial intelligence. Then we'll talk about kind of IP 101. We won't go into too much detail about the different types of IP. We're going to mostly focus on patents here, but we will talk about trademarks, copyrights, and trade secrets as well. From there, we'll go on to patents and artificial intelligence and kind of talk about the trends in AI patent activity, some of the issues you face when you try and patent artificial intelligence, international things to keep in mind, and then some other kind of whether and when, if at all, to file for AI patent protection, just some guidelines. Also, throughout the presentation, so we're learning kind of as we go as well. But for questions, I'm going to try and take a moment after every few slides to take questions. So as Liana mentioned, feel free to submit questions through the Q&A aspect of Zoom, or digitally by raising your hand. We'll try and get to them all, or at least as many as we can. And then we'll also take some time at the end of the presentation to take some questions as well. So before we get started talking about an AI overview, I do want to send a poll. I know there's probably people from all different types of backgrounds here. So one thing I want to know is, what's your experience with patents? And there's a couple of different options. Maybe you've been an inventor on a patent, maybe you've managed or overseen patents, or maybe you don't have much experience with patents. Either way, let me know, and I'll try and kind of guide the talk based on the feedback as we go. So while you all are taking a look at that, let me talk a little bit about just an overview of artificial intelligence. So there's many definitions for AI. The Department of Defense has a definition. Wikipedia has a definition. You talk to 5 different people, they probably describe it differently. But basically, artificial intelligence is kind of the simulation of intelligent human behavior by a machine. So what does really that mean? So it seems like the machine will kind of perform an action by, or you can interact with the machine that makes it seem like a person. Artificial intelligence has really taken on a lot of steam lately, a lot of traction. Basically, it's come to be a marketing catchphrase. Almost everybody says that they do some sort of artificial intelligence, but basically it's some sort of code or hardware or combination of that makes a machine kind of act or interact with a person to make it seem like it's a person. So what are some types of AI? So let's talk about a few. This list is, of course, not limiting, and the patent strategies and guidelines we talk about are going to apply to other types as well. But I think one of the most common ones is, of course, machine learning. So it's kind of the ability of systems to learn from data and improve from experience automatically. How do they work? Well, there's many different variations of machine learning, but basically there's an input data set that produces an output through a machine learning algorithm or model. And then the model kind of learns a function to tie the input to the output. This function can then ideally be deployed to handle similar and new data, so it can kind of figure out and process new inputs and still kind of come to the correct output or desired output. So in addition to machine learning, or things that may utilize types of machine learning, is computer vision. So computer vision is kind of the recognition of objects, for example, in images or video, using pixel data or other data within an image or video. It's often used for medical imaging applications, autonomous driving applications. Another type is natural language processing. So this is, for example, Siri. It's the recognition of speech and other audio. So it may identify spoken words, determine the meaning of the words, and perhaps even perform an action, such as determine, what's the weather like, or help me book a flight. So, and then there's deep learning. So deep learning can involve a hierarchical level of, for example, artificial neural networks to carry out a process of machine learning. So it can utilize unstructured or unlabeled data. There's many more types of artificial intelligence, but this is just kind of a sampling of some of the more common ones and ones that we'll be talking about today. Okay, so we've talked a little bit about artificial intelligence a little bit. Now let's kind of switch gears and talk about intellectual property. So there's 4 types of intellectual property, generally speaking. There's patents, trademarks, copyrights, and trade secrets. Today, we're mostly going to be focusing on patents. And so what a patent is it's a government-granted right which prevents others from making, using, selling, or importing an invention for a set period of time. So it doesn't necessarily allow you to perform the invention, but it lets you prevent someone else from doing something with that innovation, such as make it or use it. It's granted in exchange for a full public disclosure of how to make and use the invention. So that full public disclosure means that the applications are typically published 18 months after you file the application, or if you do disclose to have it confidential during the examination process, it's published at the time you grant. So in exchange for preventing others from making, using, or selling it, you have to disclose what it is. So you kind of get a limited monopoly for a set period of time, which is 20 years from the filing date or the earliest priority date of that application. So some of the requirements are that it must be novel and non-obvious over the prior art. It must be described in the description and include some drawings. And then it has claims that specify what you exclude others from doing. And it can be a utility or a design patent application. So most software and hardware are utility applications. They have a function, they do something. A user interface can be protected just merely as a design. It's basically a screenshot or just ornamental aspect of whatever that thing is. And then there's different types of applications. A provisional application, which is kind of just a temporary filing that kind of holds a priority date, as opposed to a non-provisional patent, which is a full application that's examined by the Patent Office. Let's see here. So why don't we, before we go into trademarks, maybe we can stop and take a question or two. So I see there's one question from Matthew Bascom. So when is it worthwhile for a small business or workshop innovator to patent their work? Without the cash flows of Google, which most of us are in a situation, Facebook or Amazon, without access to the many facets that make successful companies successful, when does it make sense for a little guy to invest in IP? That is an excellent question. And we'll get to that a little later. We're going to talk about when to file for patents, why to file for patents, when not to file for patents. So excellent question, Matthew, and we'll get to that in a little bit. So, okay, so we're going to keep going along. So let me just touch base on our poll. So the patent experience poll. So what is your experience with patents? The question, the options were, I've been listed as an inventor. Oh, we still have some people coming in. I manage or oversee patents as part of my job, or I do not have much experience with patents. So it looks like most people have been listed as an inventor. It looks like 88% of everyone has voted. 19 people have been an inventor. 3 people manage or oversee patents, and 10 people don't have much experience with patents. So it looks like most of you have some experience with patents. Either you've been involved with a patent as an inventor or you oversee patents, but there are some that don't have much experience. So we'll keep that in mind, and we'll try and cover everything as we go along. Okay, trademarks. So trademarks, another type of IP, we won't spend much time, but it basically protects a name associated with a particular product or service. So it can be a symbol, a text. It must be distinctive. It can't be generic, and it must be used in interstate commerce. So the strength of a trademark actually stems from using it in interstate commerce. So if you just think, oh, I have a great name for, a drink, if you're not using that name with a drink, like Coca-Cola or Pepsi, if you just come up with a great name but aren't using it, even if you try and file a registration, your mark is worthless. The power and the strength and the defensibility of a trademark is in actual use in interstate commerce. All right, copyright. So copyright protects an original work of authorship from reproduction, derivation, or distribution. So it doesn't protect all instances of whatever you authored, but it just protects copying or reproduction of that one work that you authored. So for example, if you, one application of copyright rights is software. So if you, come up with some original code, no one is allowed to copy your particular code. So if you do code and then some other company downloads your product, copies your code, and implements it in their product, then that's a copyright violation. And you don't need to file for copyright registration in order to have the copyright protection. Copyright rights are automatically implemented for each original authorship piece, as it's invented. However, if somebody independently creates that work of authorship, whether it's code or any other, art or anything else, if it's independently created by them and not copied by you or copied from your work or derived from your work, then there's no fraudulent act. So as long as they don't copy from you, even if they come up with the same independent thing, although very unlikely, that would not be any violation of copyright. Okay, so we've talked about the basics of AI. We've talked about some basics of IP. So now let's kind of dive deeper into patents and artificial intelligence technology in more detail. So first I want to talk about some trends in patenting artificial intelligence. So of course, there's many industry-leading AI companies, at least in terms of patent investment, that are software companies right here in Silicon Valley. These companies are investing very heavily in software and hardware, AI technology, as well as in patent protection of those innovations. Annual worldwide AI revenue is expected to increase quite a bit. So 643 million in 2016 to an expected amount of 38.8 billion in 2025. With revenue comes protection and competition. So all these companies not only are investing in their products, but also with the patent protection over those products. Artificial intelligence patent filings are also increasing in nearly, all industrialized countries. In terms of the number of patent filings, China and US account for about 50% of AI patent filings globally. So of all the patent applications filed in all the different patent offices, half of them are either in US or China. Of course, there's lots of other companies that have a lot of filings as well: Japan, Korea, South Korea, Germany, India, Russia. Israel is also has a lot of AI filings. As far as what types of artificial intelligence technology, the US, between the US and China, at least, the US has more natural language processing, machine learning, and machine vision based filings than China. And China tends to have more deep learning and machine vision filings than the US. Of course, both the US and China have both types of, all kinds of artificial intelligence filings, but those are just some of the ones that the companies tend to are specializing in those particular areas. So worldwide, artificial intelligence related patent filings are increasing quite a bit over the last few years. So this is a graph by Clearview IP. So I have a few graphs I'm going to show, and I know some of the text is pretty small, so I'll just talk about some of the main takeaways from them. But this first one basically represents patent filings through 2017, and we only have up until 2017 because patent applications aren't published until 18 months after they're filed. So this could be updated, but this company has, I don't believe they've done it yet. So anyways, in 2008, there were about 1,300 patent applications filed in artificial intelligence. In 2018, there were over 13,000 filed patent applications worldwide, which is a dramatic increase. I'm sure this rate of increase is going to top off eventually, but it does show that artificial intelligence and machine learning patent filings have really taken off on the worldwide stage. In this graph, also by Clearview IP, it shows the top assignees, or the top patent owners, basically, for artificial intelligence and machine learning published patent applications. So worldwide, the top owners of patent applications that have been published are Microsoft in blue, IBM in green, and then Baidu, Google, and Facebook. And then one of the last graphs I have here, this one just shows the terminology found in granted patents. And the terminology is broken up into machine learning technique, machine learning hardware type, application type, and other information. So I think they'll provide a copy of the slides so you can see in more detail once you have the slides if it's not clear in the webinar. But basically, machine learning is above and away the top technique used in most filed patents. Computing devices and vehicles are the top hardware types. Applications include databases, images, and sensors as the top applications for artificial intelligence patent filings. And then in this last chart, I promise it's the last chart I have, this provides some data as application fields versus artificial intelligence techniques. The main takeaway is that computer vision for telecommunications and transportation has some of the most filings with over the globe, according to the World Intellectual Property Organization. Okay, so enough charts. So let's talk about the kind of the core aspects of AI patentable. So some of the issues in AI patentability, it basically comes down to two main issues. Inventorship, which is who conceived of the claimed invention, who invented the invention you want to patent, and then subject matter eligibility. Is it in a form of something that can be patented? So as far as inventorship, the USPTO defines an inventor as an individual. So what's an individual? It doesn't really say. So an individual, it's kind of a gray area. Is it a person? Is it an individual company? Is it an individual entity? It's probably a person, but it doesn't really specify. Other patent offices, such as Europe, the European Patent Office, or EPO, they define an inventor as a natural person. And obviously a natural person is just a living, breathing person, such as myself. So in foreign patent offices, an inventor definitely is a living person and probably can't be a machine. In the USPTO, an individual probably needs person, doesn't specifically rule a machine out, so it's not a completely black and white issue, but it's probably needs to be an individual. There's some other issues with the US Patent Office that kind of help us come to a more solid recognition of inventorship. And that is some rights and duties of an inventor for the US Patent Office. So when there's a patent application, it must have inventors, and each inventor must be able to sign an oath. And in that oath, the inventor confirms that it is their invention described in the patent application, that they're the first inventor or a joint inventor, and that false statements can be punishable by a fine or prison. So can a computer understand concepts and make a decision to sign? I would say no. An inventor can also assign their rights to another person or an entity. I don't think maybe a machine could sign, probably not. Could they make an oath or sign an assignment? Probably not. So in the US, because an inventor, even if it's an individual, it doesn't clearly say it's a natural person, but they need to be able to make an oath and sign that they understand the oath they're taking. They probably need to be a live person. So an innovation generated by a machine, conceived by a machine, is probably not patentable. So although it hasn't been addressed by the statute of the courts, it probably will be in the next few years by Congress, just because artificial intelligence patentability is becoming a very big issue. So now we've talked about, well, first let me pause for some questions. So I don't see any other live questions. Let me look at the chat.
Steve, yeah, there's a couple questions in chat. Thank you, Steve.
Okay. So looking through chat.
Bill asked, is a copyright automatically created? Don't you have to put a copyright notice on it?
If you want to reserve the right of a copyright, yes, you do need to put the notice on it. But I guess the point I was trying to make is that you don't need to file a copyright registration with the Copyright Office in order to declare that you have a copyright on your work. So yes, you need to put the copyright notice on there, but you don't need to file that with the US Copyright Office in order to maintain your copyright rights. There's another question. So why wouldn't the people who trained and created the machine learning models be the inventors by proxy of any inventions created by the machine learning model? So why wouldn't people who trained and created the machine? So we're going to get to that, the specific details of what aspects of a machine, an artificial intelligence machine. So there's several aspects of an artificial intelligence system or machine. There's the input data, there's the model or the algorithm, and there's the raw output of that model and algorithm, and then there's the the application of that data to an overall system. To answer the question, why wouldn't the people who trained and created the machine learning model be the inventors by proxy? Well, though they created the overall system, but the raw output of the model is not generated by the people, it's generated by the model. So currently, the stance of the U.S. Patent Office is, and many other patent offices, is that the pure output of a algorithm or neural network or deep learning series of networks, that just raw instant pure output is not patentable because it's generated by a machine rather than a person. So there's other aspects in that chain, for example, the application of the output, or maybe perhaps the machine itself, not what it generates, but the machine itself, if it's novel, or processing of the input. All those aspects might be patentable, and we'll get to that, Abraham Kang, in a little bit, but that's the current stance right now. And then we have one more question from Ahmad. Would it be safer to add more inventors than less inventors for a patent? Basically adding the members who have been involved with the design. Excellent question by Ahmed. So the U.S. for inventorship, the U.S. Patent Office requires that all the inventors who conceived of a material part of the invention be listed. So, and this comes up a lot. Sometimes the powers that be of a company will want to list several people, for marketing purposes, saying, oh, here's our CEO, and he's listed on 50 patents. Any patent that comes through the system, they add the CEO or the CTO. That can be an issue later on if it's litigated and the other side questions whether there was fraud on the listing of the inventorship. The U.S. Patent Office only wants inventors listed who have conceived of a material part of the novel part of the invention that's claimed in that patent. So would it be safer to add more inventors than less inventors for a patent? No, not necessarily. And you need to actually add the inventors that conceived of a material part of what's claimed in that patent application. So we'll get to this in a second, but oftentimes a patent will cover, for an artificial intelligence system will cover anything that's done, any pre-processing of the input data, maybe the training process, the model itself. It'll describe the output, and then it'll also describe the overall system, which utilizes that output in order to determine something of value. So there might be different people responsible for different parts of that process. But you only want to add the inventors that have conceived a material part of what's claimed in that particular patent. So that this patent might cover maybe just the processing of the input, or maybe just the model, or maybe it is the overall architecture. But you don't want to be safe by adding, throwing in more people than not, could come back and hurt you later. Let's see. I'm going to continue on, and we'll take some more questions as we go forward. Okay. Okay, so issues in patentability. So to be patentable, a patent application must be novel, so it must be new. There must not be anything just like it, which is usually met very easily. It must be not obvious. So it must be not obvious in light of prior art by a person of ordinary skill. So it must not be easily suggested by combining prior prior art references or otherwise obvious. And it must be patentable subject matter. And this is where software sometimes has an issue. So the invention must be a new and useful process, machine, manufacture, or composition of matter, or a new or useful improvement therein. So there are some judicial exclusions to patentable subject matter. So some things that are not patentable are laws of nature. So you can't patent the law of gravity. Natural phenomena like rain, you can't patent rain. A pure mathematical formula or an abstract idea. And the one that comes to be an issue with software is the abstract idea. So the Supreme Court addressed this issue in a case, Alice Corp versus CLS Bank. So I don't want to spend too much time on case law, but basically they provided a two-part test. So first, are the claims directed towards a judicial exception, such as an abstract idea, which is generally applied towards many types of software? And if so, does the claims in the patent application have elements that transform the nature of that claim into a patent-eligible application? So do the claim elements addressed to software amount to significantly more than an abstract idea? Without spending too much time on case law, I just want to mention that the Court of Appeals for the Federal Circuit has held that software inventions are patentable if they meet certain requirements. So for example, if they're rooted in computer technology, for like encryption or video conferencing, or if they improve computer operation. For example, do they make the computer more efficient or faster or use less memory? Do they use a non-conventional arrangement? So are the components rearranged in a new order or a different order that wasn't done before with unexpected results? Or does an automated process differ from a prior process that wasn't automatic, perhaps done by manually? So for example, does an automated method for generating animation require different or modified steps than a manual process of doing animation? So if these four aspects are satisfied by the invention and the patent application, then the software, even though it may be initially characterized as abstract, may recite significantly more and be patentable. So subject matter eligibility. So for an artificial intelligence related software invention, it could be potentially patentable if the patent application claims recite significantly more than an abstract idea. So this is an ongoing issue with patentability, and more changes are likely to come within a couple of years addressed by Congress. So that's kind of the excuse me, aspects of artificial intelligence patentability in the US. So before I jump into patentability of the EPO, I'll take a look at some more questions. I'm going to start by looking at the Q&A. So Srinivas asks, if I regenerate an image or a video by leveraging GAN or autoencoders, like a variation of a Mona Lisa picture, is it copyrightable? So if you regenerate an image, you're probably copying it. So it's a derivation of the original one. If you regenerate an image by video or leveraging the GAN or auto. Potentially, so you might be infringing their copyright because you're kind of making a derivation, but something could potentially be copyrightable if by if it's the original work of authorship. So you'd have to make significant changes, very significant changes to it, however. I hope that answers that question.
Could it be, Steve? Could it be related to style? Is style at all patent or copyrightable?
So if you're changing the style of something, if you're still generating something, if you're still basically generating something based, starting from something else. If you're starting from something else to make your own aspect, then there is a chance you're infringing the copyright of that original work of art. So is yours copyrightable? Potentially, but you might also be infringing the original copyright work as well if you're making a derivation of that original work. So going on to another case, or another question. In light of Alice, can a business process be patentable, assuming that it is non-trivial? So for something to be patentable, it must be subject matter eligible. And for something to be subject matter eligible, it typically needs to be something physical, something under the sun. For example, a product, a system, software executed by a processor and stored on memory. Business processes are generally not patentable if they're acts performed by a person or multiple people. So is a business process patentable, even if it's non-trivial? Probably not. If it's something that's completely done on a computer, something that's implemented on a computer, then yes, it has the potential to be patentable. But if it's a business process performed by people, then no, it's not. Let's see. So there's one question about patent issues and enforcement issues. How can I tell if a patent is being violated? So patent enforcement and detecting infringement of your patent, that's a little bit outside the scope of just patentability of artificial intelligence. It's a very good question. But what we're talking about here today is more related to what types of AI are patentable and how and when should you patent it. As far as enforcement, there's companies you can hire to look at, keep an eye out for products. You can monitor competitors. That's some of the ways you can tell if it's being violated. Another question is, I was told that patents give the right to sue, but not the obligation to sue. What other value is there? So if you don't sue on a patent, what is the value of a patent? Well, you can cross-license a patent. If you're sued, it can help you in cross-licensing. It can help you in potentially raising funds by reducing risk for investors. We'll get to that in just a few more slides. So I think I'm going to move forward with some more slides, and we'll take some more questions in a little bit. So getting back to international patentability of artificial intelligence, the EPO has two hurdles generally to overcome for patentability. An invention must have technical character, which is similar to the novelty aspect in the US Patent Office, and the claim subject matter must contribute to a technical solution to a technical problem. The EPO is of the point of view that artificial intelligence, and in particular machine learning, are computational models and therefore abstract and mathematical in nature, and are therefore not patentable. That said, well, I guess in addition to, they issued some guidelines for patentability about a year and a half ago in November 2018. And in those guidelines, they've instructed their examiners to look for artificial intelligence and machine learning buzzwords to reject certain claims. So if the claims in an EPO application include phrases or words such as neural networks or reasoning machine or support vector machine, they will reject them, saying that those phrases relate to machine learning or artificial intelligence and are therefore directed to a mathematical model. EPO, artificial intelligence application claims, can be patentable if the underlying algorithm or computational model contains a link to a technical purpose. For example, there was one case before the EPO that was issued as a patent, which did include the word neural network, but further claim that it uses a neural network and heart monitoring apparatus in order to identify irregular heartbeats. So there they link the neural network to the technical purpose of heart monitoring apparatus, and in particular to identify irregular heartbeats. So if you expand, not just that you're including some of these aspects of artificial intelligence, although I still wouldn't include neural network. If you specify what it's being used for, that will help an applicant in front of the European Patent Office. Other countries have similar approaches to the US and the EPO. China has a harder stance and has indicated that subject matter eligibility of software is determined with respect to the technical solution, which is similar to the EPO. Japan has a software subject matter eligibility more similar to the US Patent Office. So they're a little easier on software patents than China and the EPO. All right, so copyright, very quick. International copyright, that is, for artificial intelligence. So as we talked before, a copyright is granted to the creator of an original work. In the US, a copyright is not granted for art produced by a machine without any creative input or intervention from a human author. So an individual has to be creating the machine or providing input to the machine in order for it to grant a copyright in the natural person author. In the EU, a copyright cannot be granted to a computer. It must be 100% generated by a person. Okay, let's see. Are there any other? Lots of questions. So let's take a second. Before we jump into patent strategy, I'll try and answer a few more questions. Let's see. One question is, can I give examples of software patents that are not abstract ideas in comparison to things that are abstract ideas? Off the top of my head, I don't have those software patents prepared to discuss, other than the the 4 case law examples I give. Those all relate to particular patents. And this is for Abraham. Abraham, if you want to email me afterwards, I can email those to you, but I'm not going to dive into that right now during this presentation. Do we need to file a patent? So another question, do we need to file a patent in each country, or is there one door entry? So there is, wherever you, so to take a step back, patent law is specific to each country. So if you file in a particular country, for example, the United States, your patent is enforceable in the United States. For a patent to be enforceable in France, you need to file in France. That said, there is a treaty called the Patent Cooperation Treaty, or the PCT, which allows you to make it a somewhat more efficient process for filing in foreign countries. What some people do who decide they want to file in foreign countries is file one PCT application, and then that gives you 30 months before you have to decide which individual countries you want to move forward in. But for each country that you want to file a patent in, you do need to select that country and move forward in that particular country. There are some groups of countries, such as the European Union, which you can expand into from going through examination in the European Patent Office. But to answer your question, do we need to file a patent in each country? You do need to file a patent in each country in which you want to prevent others from doing your invention. It certainly doesn't always make sense. Foreign patents are very expensive. And one thing I tell my clients, just consider 4 or 5 factors before determining which country you want to expand in. Just to address one of those factors here is it's going to probably cost about $4 to $5 million to litigate a patent in a foreign country. So if your business is making maybe $1 million and there's a competitor that's raking in maybe 500K, it's going to cost you $5 million to stop that competitor from taking 500K of your business. Is that worth it? Probably not. So I probably wouldn't recommend filing in any country, or at least one of the factors you consider is, are you making at least 5 million in revenue in that particular country to make it worthwhile to even sue someone if they're taking it. So that's not the only factor, but that's an important factor. All right, I'm going to take one more question. Speaking of patent trolls, is it worth patenting all patentable pipeline, even if trivial, just to protect against patent trolls? I would say definitely not. And in a couple of slides, we'll talk about some things to keep in mind when discussing or when deciding what to patent and when not to. Okay, and I know there's more questions, and I'll try and get to all of them maybe when we're done in a few more slides. Okay, so artificial intelligence patent strategy. So there's, after doing, after being a patent attorney for 20 years and doing artificial intelligence and machine learning and other types of AI patent applications for at least 10 years, I've come up with some guidelines and things that have worked, especially in view of some of the recent requirements in view of Alice for software patents and some of the other cases that have come down. And these next few slides are going to summarize those. So in the specification, which is a written description portion of a patent, you want to include a paragraph or two about what the technical problem is and what the technical field is, and a summary of the technical solution of your artificial intelligence-based invention. So, and this relates to software patents. So software patents might be considered abstract, and one way to get around that is if you describe what the technical problem is, and if your claims provide a technical solution to that technical problem. If you can, it's best to not just rely on one bullet, but maybe several different shots at it. So don't just recite one example or just one problem or one technical solution. List as many as you can. This will just make your patent application that much easier to defend when it's being examined at the patent office. Another is to describe and claim improvements to the computer technology. So does your artificial intelligence-based software application make a machine faster or more efficient, or utilize less memory space? How does it improve the computing devices, the computer hardware, or the system overall? And then though just a few patent offices are keeping an eye on this, such as the EPO, it's probably always a good idea not to overly rely on buzzwords, especially in the claims, such as neural networks, reasoning engine, support vector machine, and so forth, especially if you're foreign filing. Do use technical terminology in the specification of the claims, and identify signals and data types, databases, interface types, protocols, and so forth. And do recite the interactions between the hardware and the data associations, such as control data going from what generates it, what sends it, and what receives it. All those details are very good to include in the claims and the specification. And then for strategy, so this was the this kind of relates to one of the questions I was asked earlier. Should we include lots of inventors and just claim the whole thing? I would recommend that you spend some time really thinking out what the whole system is and what you want to try and protect. What you think is novel and non-obvious, but that might include the data preparation. Are you doing anything for the data that trains the system? Or data that's being processed by the eventual algorithm or model? Are you modifying the model structure, or is it just an open source model? During the training phase, is there anything you're doing that you think is different and novel? And then the output data. So the raw output data, that's generated by the model, and that raw output data, just the pure data, is probably not patentable in and of itself, but the system that uses that data to do something else, maybe take that, a probability and process it, or otherwise, transform it into some other information or output, that could be patentable in view of the entire system. And then of course, just the whole hardware architecture, that's potentially patentable as well. And then as a continuation of that, describe the entire system, including the use of the output, the training phase, the model structure, and so on, the pre-processing of the training data, use of classifiers, end-to-end workflow description, the hardware that provides the input and to and receives and uses output of the AI system. Describe as much of the system as you can, including use of the output, in as much technical detail as possible. So we have just a few more slides about details for filing AI patents. We'll get through those, and then we'll just go through as many questions as everybody has. So filing for patents. Why would you want to file for any patent at all? So there's a patent. One thing for one use of a patent is to sue somebody. So you detect that somebody's using your invention, so you sue them. Lawsuits are very, very expensive. They call it the game of kings, and most companies want nothing to do with a patent lawsuit. They don't want to spend the money, and they just have better ways to use the resources. So some other things that patents are useful for are in attracting investment. If it's a startup company or an early stage company that might be looking for some VC funding, or to be potentially acquired, sometimes VCs will want to know that there's a patent pending, or at least some sort of IP plan in place, so that they know that their risk, investment risk, is going to be lowered. Also, oftentimes, if the goal is to be acquired by a company, for example, a company that's based in South Korea or a company that's based in Japan, that company may look favorably on not only patents in the U.S., but their home company, or I'm sorry, their home country, like Japan or Korea. Of course, there is another reason is to prevent the theft of innovation. So you could potentially sue someone to stop them from infringement, but again, that's expensive. What happens much more often is if there's a joint development agreement between two companies, and what one company owned before the joint development, and then what the other company owned before joint development, and then who owns the rights to the jointly developed technology. If you have some important aspects of technology that you want to make sure are yours and aren't intermingled, one clear and cut and dry way to do it is just file a patent application, at least a provisional application, on the technology you already have. And then list that technology as patent application number ABC XYZ, so that it's not going to be mischaracterized or lost through a joint development agreement. Another one is just to avoid litigation. Oftentimes, when a bigger company makes a decision to sue someone for patent infringement, they're going to do a search to see what patents, or at least pending patent applications, that potential defendant has. So if you have some patents, a patent or two owned yourself, or at least maybe another patent application or two pending that might be close to being allowed, that could make a potential lawsuit filer take notice, perhaps make second thoughts about filing the lawsuit, or if nothing else, you can use that as leverage to cross-license or settle the case. Also, at least startups that file for companies, they tend to be more successful. So companies that have filed for and obtained patents on their own homegrown technology tend to have better employment growth, sales growth, more likely to secure VC funding, and just more likely to be listed on the stock exchange. And that's from a Harvard study that was done a few years ago. So there's lots of reasons why to file for patents, why not file for patents. So one question was, why not just file for everything you have? Well, infringement may be difficult to detect. If the aspect makes something, if the invention makes something run better on a back-end server, or for example, just provides a some sort of generation. For example, Pandora, comes up with a song choice, or a song list, playlist, in a way that's difficult to detect whether or not it's copying, then it may make sense to not file a patent. Pandora doesn't have any patents on its song processing algorithm. So in addition to difficulty in detecting infringement, if reverse engineering is difficult to achieve, that might be another aspect. Patents, once filed, are very slow, so they often take 2 to 3 years to obtain. If the technology is very valuable, but it's going to be obsolete in a year and a half until something else is innovated, it may not make any sense to get a patent if it's going to be obsolete before you get a patent. Also, if the innovation value is going to outlast the granted patent rights, so a patent lasts for 20 years. If your technology is going to be valuable for 30 years or 40 years, then you may not want to, you might rather keep it a trade secret so that it's not going to be public domain after the patent expires. Also, the innovation may just not be patentable or not be aligned, not be valuable for your business goals. When should a company consider getting patent protection? Well, if you're going to be looking for VC funding, you might want to start the process 2 to 3 months before you start going to VCs. If you disclose your technology to a third party, a joint developer, somewhere before you do that disclosure, you might want to consider it. And also, if you're on track to take away a competitor's market share in the next 1 to 2 years, it takes a good, oftentimes 2 to 3 years to get a patent. So you might want to get something in the pipeline if your technology is going to take away significant market share from a competitor that has a track record of being litigious. So then for artificial intelligence patents or any sort of patent, what should you patent, if anything? There's lots of factors to consider, but 2 of them are how valuable or in line they are with business goals and how likely patentable that aspect is. So if something is very valuable and very likely to be patentable, then that might be a high priority patent candidate. If something's very valuable but unlikely patentable, then that's something you should probably keep as a trade secret. If it's not patentable and maybe less valuable, then maybe that's something you generate to open source or at least don't consider for patent protection. And then everything else, maybe you just kind of prioritize it and then look at budget, other things, and just make investigate it further. Okay, questions. Let's go into some questions. Abraham King has lots of questions. I've answered a few of his. I'm going to go to somebody else's. Okay, so K-Rod says, to clarify, if a business process is implemented in software or using artificial intelligence and is non-trivial or software, can software or artificial intelligence make a business process more efficient? Will it be allowed? If a business process is implemented in software using AI, then it can potentially be patentable. So as long as it's implemented in software, it might potentially be patentable if the aspects, the elements in the claims make it more than an abstract idea. So K-Raj, if you want to email me offline, and I'd be happy to talk to you on the phone for 20 or 30 minutes, and we can go over it further, and I can give you my gut feeling. But potentially it is patentable if it's implemented in software. And then one question is it okay to claim someone else's patent derivative in a different country and file in another? I actually hear this question more often than not. So if someone invents something in China, and you say, wow, that's a great idea, I can make some money on that in the US, can I then file in the US and prevent anybody else from doing that in the US? No, you can't. So one thing, as part of the oath as an inventor, an inventor in a patent application takes an oath, and part of that oath is that you believe you are the first inventor. So if you are basically getting this idea from some other source in China or some other country, then you are not the inventor that other person is. So therefore, you can't file somebody else's great ideas if they're in another country just because they're in a different jurisdiction. If you were to invent it honestly and independently, then you could. However, that there is that prior art from a foreign country could potentially be used as prior art against yours since it was done earlier. Jay Diamond asked, will your slides be available? Yes, I believe they will be available. One question, how often do you have to go into an appeals process or an appeal committee? So before the US Patent Office the way the process goes is you file your patent application, it's examined, and then they provide what's called an office action. And then you can respond to that office action. They'll then do another final office action. In response to that final office action, you can continue prosecution and just submit another response. And in your response, you can argue against the rejection. You can tweak your claims a little bit and submit arguments. You can submit declarations. You can do several different things. But also in response to a final office action, you can submit an appeal. You can basically appeal and go to the next level up in at the patent office in response to a final office action. So the question, how often do you go into an appeals process or an appeal committee? Not very often, but that option is available to you. But I would say, me personally, less than 10% of the cases that I prosecute, we actually appeal. Another question, is a trade secret the same as a trademark? No. So a trademark is like a name, a trade name for a product, such as Coca-Cola is a soda, Pepsi is a soda. Coca-Cola and Pepsi are trademark names. A trade secret is some sort of knowledge or information or data that a company has that gives it a competitive edge that it keeps secret in its company. So it's could potentially be the subject of a patent, but instead of trying to file a patent, being able to protect that idea and exclude others from using it, you're just kind of keeping it a secret inside your own company. So another question, if I train a vision-based model on a client's images, can I later continue training the model on other data and resell the model? I believe so. It would depend on what the rights, this would probably depend, at least in part, on contracts between you and your client, who would have the output. And lots of questions coming in. I just lost your question. But anyways, it would probably, at least part of it would depend on the contract between you and your client. How can they use my data? Can you continue to use the data or derivatives of my data, or in particular, models or algorithms developed based on my data, after our relationship is used, for your own profitability. So it's probably a contract issue. David Horn, should I consider disclosing an invention to prevent others from patenting the same idea? That's definitely an option. So if you, and that's a cheap way to, if you don't want to pay to have something patented, but you don't want others to patent the same idea, you can disclose it and submit it as prior art. So one of the more reliable ways to disclose it is to file. I've actually never done this, but there's a document you can file with the patent office which discloses your invention, but it's never examined. It basically just makes it go straight to prior art. So that is an option. Should you consider disclosing that? That's a business decision, but it's definitely an option if you want to have your technology used as prior art against others. And yes, Ahmad, a follow-up question to the Coca-Cola example. So the name of the product is a trademark, the recipe is a trade secret. That is correct. So when is it, Matthew has a question, when is it worthwhile for a small business or workshop innovator to patent their work? Without the cash flow, yes, patents are expensive. Without access to all the resources that the bigger companies have, when does it make sense for a little guy to invest in IP? I would go back to that slide. I think you probably wrote this before we got to that slide, but I would basically, if you're looking for VC funding and a VC, you talk to a few VCs and say, hey, would you, I have this technology, would you need to hear that it's patent pending before investing in me? If they say yes, then perhaps file a provisional patent application. If you're going into a joint development with someone, excuse me, then you might want to consider doing a a provisional patent application in that case, or at least making it very clear that what your technology is, very clear description of it. When does it? But patents are expensive, and it's a very slow process for very small businesses that probably aren't going to be litigating. It may make sense to actually not patent and keep things a trade secret unless you're looking for funding or going into joint developments, or there's really an expectation that your business can really take off and take notice of some bigger competitors. I hope that helps, Matthew. How would I classify let's see, how much does it cost to file a patent application for an individual? That's the $100,000 question. So it varies. Provisional patent applications are usually cheaper than non-provisional patent applications. What I tell my clients is, for a non-provisional application that's going to be examined and potentially issue into a granted patent, you should expect to pay between $20K and $25K, between $20,000 and $25,000 over a course of 2 to 4 years. That's probably how much it's going to cost overall. Some of that's going to be up front in the patent application filing. Some of that's going to be, responding to office actions, possibly appealing, and then, doing an assignment, the oaths, and then once it's granted, the issue fee. So one question by Ahmad: if you had made significant innovation changes since the patent was filed, do you just keep filing new patents or modify existing patents, or do they become protected by default? So once an application is filed, you can claim anything that's described by that patent application. You can change the claims to cover different parts of the written description, but you cannot add to the written description. So if you've come up with significant changes that aren't described in that patent application, they will not be covered by that patent application. So if it's something that you really want to patent and you think it's going to be valuable and worthwhile, then you either need to file a new patent application, or if it's related technology, you can file what's called a continuation in part, which for the overlapping part of the technology, between the original, what's covered in the original application and the new application, it'll include the same priority date, which is helpful because it'll basically predate some prior art for the content that's already in the existing application. Ahmad, if anybody has specific questions that I'm not getting to or not answering in the way you want, I'm happy to talk to anyone over the phone for 15, 20 minutes, even 30 minutes. I'd say meet in person for lunch or coffee, but we're not going to be doing that for a while. So we could do a Zoom, I guess. But feel free to reach out to me. I'm happy to talk to you guys if you want to reach out to me by email. Ahmed, I hope that answered your question. Very welcome. So another question from Matthew: how would you classify discoveries made by AlphaGo? I'm not sure what AlphaGo is. Humans now study previously unknown sequences discovered by the AI. Does protection stop at those discoveries that might make a computer faster, for example, and reside in the realm of trade secrets but not IP? Let me reread that question. Humans now study previously unknown Joseki sequences discovered by the AI.
I think that's like opening book moves in chess equivalent.
Okay. Does protection stop at those discoveries that might make a computer faster, for example, that reside in realm of trade secrets but not IP? So they're discovering, it's a machine that discovers chess moves, if that's how I understand it. So this is a tricky one. So the art, making a chess move is done by a person. So you can't patent, a particular chess move. The act of discovering a chess move might be done by a machine, so, by AI. So that might potentially be patentable. So does the protection stop at discovering the move? Yes, it would, because the actual making that move is done by a person. So, and you can't patent what a person, a physical act by a person. So any potential protection would stop at the discovery of it, or possibly maybe some implementation of software in a game, but probably not. So it's probably, the protection probably stops at discovery. Abraham has lots of questions. I think Abraham and I are going to have a long call one of these days soon. Greg, if I train a vision-based model on a client's images, I actually already did that one. Can I continue training the model on other data and resell the model? Let me, again, I think there's a lot of things that play for that one. I think part of it is, what is the client's expectations of how you're going to use their data, their images, who owns the resulting trained algorithms or machines. I think that's probably the main question. Is what was the agreement with the client? But if the client doesn't express interest or any limitation on using the training model that was trained based on their data, then I believe you could continue using the model, as long as the model was yours in the first place. So my fellow panelists, are there any other questions other than Abraham's?
I have one, Steve. This is Carl.
Okay. Hi, Carl.
You were talking about some creative input, as a requirement from the user, like you were generating art. So would just the random seed itself, just some random input, would that be sufficient? And the rest, like for GANs, it might be just a sequence of bits that, you're just typing on the keyboard, banging the keyboard. Does that count?
Are you starting from scratch? Are you doing something over a pre-existing work of art? So are you
trained a network to use this random input to generate stuff? So I think this is a copyright issue, right?
It's a copyright issue. So, but one, you're not supposed to use reproduce copyright for that same purpose. However, that is a very good question, and one that hasn't really been addressed by the courts. So if you use voice, for example, podcasts over to train your model, or images to train your model, is that a copyright issue? I'm not going to say one way or the other, because I don't really know, and I'm not sure many people know at this point. You're not really reproducing that image. You're not selling that image. You're not distributing that image. You're taking data from the image to generate something different that's not really related to what that original was. You're taking data from that image or data from that audio recording to come to a probability score or something like that. So it is a copyright issue as to how much do you need to change the data in order to use that data, or are you even is it a fair use of that data to take that data and use it to generate something completely different? It's an interesting question, and one that I don't think there's an answer for yet, but it's one that certainly will be addressed, because one of the most valuable things in neural networks and artificial intelligence and this processing is the training data, getting good training data. So it's becoming a bigger issue. And copyright is one of the deciding issues, but I don't have a clear answer. Do we have any other questions from panelists or anybody?
Hey, Steve, this is Karthik. So we talked about a lot of things about AI patenting. So my question is there anything special patenting law for AI, or what makes you to bring up this topic?
Can you repeat that last part of the question?
No, what makes you interested in bringing this topic to the audience?
what makes me interested in presenting this topic to the audience?
Yeah.
Artificial intelligence is a technology that's raising some very new issues. You know, it's generating some of its own output, and just the issues of it. You know, the inventorship issue. You know, at what point do we cross the line where you know, machines, you know, can pass as people? We're not there yet. You know, can machines make an oath? Can you trust a machine? Can machines sign on behalf of themselves? No, they can't. So at this point, they're not really considered an inventor. But in 15, 20, 30 years, who knows what kind of rights and capabilities will install in some machines, or networks, or, you know, overall systems. I think it's a very interesting subject, and with the, you know, development and progress and the you know, the rocket the rocketing rates of development that are going on, it's just, you know, patenting is just a very, you know, patenting is what I do. Intellectual property rights, assisting people with intellectual property rights is what I do. And it's just a very interesting question where some of the issues are clear and some of them are a little gray. So I just find it fascinating to talk about.
Okay, thank you.
Sure. Okay. Well, if there are no further questions, I just want to say thank you again to everybody for chiming in. This is one of our first webinars. We're very happy that you joined us. Again, if you have any other questions, please feel free to reach out to me, or the if you have content questions, if you have, you know, general webinar questions or any other thoughts about the SFACM or their future events, please feel free to reach out to the organizers. We will be sharing the slides soon, and otherwise, thank you very much.
Thank you, Steve. And we're close to the meeting. And so if anybody else have any comments or feedback, you can welcome to do that on the Meetup Common page. Thank you very much.
Yeah, thanks, Steve. Thanks.
Thank you all. Take care. Stay safe and healthy.